Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court, and we are here with your legal news roundup. All the legal news happening in your world so that you might be better legally informed. We begin with breaking news this morning. Dianne Feinstein, senator from California, has died at the age of 90, which of course is sort of a culmination of recent news in which her health has obviously not been necessarily the best. So this has sort of been a thing that was coming for a while, and it has now come, and that is where we are. So let's discuss this story. Let me adjust the margins just a second because it doesn't look quite right. I don't like it. Fix the margins. Fix the margins. There we go. Make it look all nice on the page. Look nice on black and white. There we go. That looks better. Great. Dianne Feinstein, who is the longest serving female senator in United States history, died on Thursday night at the age of 90. This was confirmed about an hour ago or so. So she died last night, but news is just breaking this morning. She had been hospitalized for what we were calling shingles since the beginning of March, and her health had deteriorated, as you know, anyone who could observe it would note. So this has been a thing that has been coming for a bit and a while at this point. Dianne Feinstein has dedicated her life to politics and public office. She was a politician of many firsts, the first woman to serve as president of San Francisco's Board of Supervisors, which is, you know, the town council, the first woman to be elected mayor of San Francisco, the first woman from California to be elected to the Senate, and the longest serving senator from the state of California, also becoming the longest serving senator for women in 2023. So she's been around for a while. She served a whole bunch of capacities, served as San Francisco initially on their board, officially as their town council, then a mayor, and then a woman senator, and has been there for quite a long time serving the state of California. So that has happened. Feinstein was born in 1933 in San Francisco. After graduating from Stanford, everyone's favorite university on this channel, in 1955, she was appointed to the California Women's Board of Term and Paroles in 1961. So she sat on the parole board initially as one of her first jobs in public service. And she sat on that board for 5 years. Later, she was appointed to the San Francisco Advisory Committee on Adult Detention, which continued to inspire her to pursue a career in politics. In 1969, she ran for the San Francisco Board of Supervisors, basically the town council, a position that she handily won, becoming the first president of that council. The race for supervisor in 1969 was interesting because conventional wisdom said women voters would only elect one woman to the 11-member board, and since a woman was running for re-election, one of us was bound to lose, she reflected in a newspaper article in 2020. It turns out we both won, and I was the top vote getter, which made me president of the board, another first for a non-incumbent. So, you know, she obviously was popular in San Francisco. She got the most votes of anyone running for the board, becoming the first non-incumbent ever to become immediately the president of the organization by getting the most votes. So, you know, whatever can be said for her, she definitely was able to understand the constituency in order to get its votes. In 1971, she decided to run for mayor of San Francisco. Although she came third in that race, she was reelected to the Board of Supervisors, where once again she received the most votes among members of the board. In 1975, she launched another bid for mayor, but lost again, coming in third place. The following year, there was a explosive thing placed on her home by the New World Liberation Front, but it misfired, leaving her unharmed. So, you know, she was controversial, including by members of the left at the time. So she, you know, gained some enemies at last. In 1978, she finally became San Francisco's mayor, but only due to somewhat tragic circumstances. The then mayor, who was George Moscone, and supervisor Harvey Milk were assassinated, allowing Feinstein as president of the board to assume the position of acting mayor. So she became mayor initially by assassination. She became mayor because other people got assassinated, and she was next in line for succession to become mayor. So she became mayor through line of succession initially. The following year, she was officially voted in as now an incumbent, making her the first woman to be elected the mayor of San Francisco. So initially, that's sometimes how it happens. Sometimes how it happens is a person is thrust into a position, and then people like the fact that they're in that position. We've had presidents become president through such means. And sometimes people like that person when they become president. So they might not be able to win an election in their own right, but through assassination, they become president or become mayor or become whatever. And then people are like, oh, we actually do like that person, and keep voting them in. So that certainly has happened and is what happened in her case. As mayor, Feinstein proposed a ban on handguns after the assassination of Moscone and Milk, sparking a backlash at the time. So Feinstein has long had problems with the Second Amendment. Anyone who's a Second Amendment person knows that Dianne Feinstein is no friend of the Second Amendment, but it's not exactly a new position in terms of her politics. She has opposed this and opposed the Second Amendment since the very beginning. The White Panthers, a political collective that opposed Feinstein's gun control measures, launched a recall campaign to remove her from office in 1993 and initially got enough votes together to force the issue. Feinstein, however, overwhelmingly won the election, saying, I don't think this will stop anyone from filing against me, but I think anyone who does so is going to be creamed. So, controversial, even among her own constituents, forcing a recall election, but she was able to withstand it because, she was overwhelmingly popular. During the time as mayor, a position she held until 1998, Feinstein enacted a handgun ban, traveled to China, and steered San Francisco through the height of the HIV epidemic, which, of course, in 1988 was quite an unknown entity at that time. So, and was hitting San Francisco particularly hard. So it was a tough time to be the San Francisco mayor. You had this brand new epidemic, which at the time in 1988, no one was quite sure what was causing it. And it was causing real problems among her constituency. So, it was a difficult time to be steering through that issue. According to San Francisco Chronicle, Mayor Feinstein's AIDS budget for San Francisco was bigger than the president's AIDS budget for the entire country. So she was spending more on the problem than the national government was nationwide, which, makes a lot of sense because San Francisco was being particularly hard hit by what was then an unknown disease. And so they were spending a lot of money on the local level, trying to deal with it on the local level, which makes, a lot of sense from first principles. Let the localities deal with it as they need to. Let the states deal with it as they need to. The fact that the U.S. government was more hands-off and the state was more active is more in line of keeping with basic fundamental federalist principles, that the state and locality are in the better position to deal with health crises because they will vary from place to place. So the steps she was taking were notable, but arguably matching the unknown factors at the time and trying to deal with the fog of the unknown. And it was being done on the local level, which presents significantly less legal problems than it would be on the federal level because states have police power where the federal government does not. So the fact that they're trying to institute measures on the local level, more defensible from a legal position. That isn't necessarily to say everything she was doing, of course, was legal, just simply that it poses less legal problems. In 1990, Feinstein won the Democratic nomination for governor of California, the first woman in the state to win the nomination, but she lost that particular race. Later, she won a bid for U.S. Senate in 1992, which she declared Year of Woman after 4 female senators, including Barbara Boxer, were voted in the Senate in the same year. So she was part of a trend of increasing women in the United States Senate. As senator, one of her first things that she did was passing a ban on production of semi-automatic assault weapons. So as I said, no fan of the Second Amendment, but in no sense a modern position. That had always been her position from the first time she was mayor. Apart from that, she advocated for protecting deserts, championing LGBTQ rights, crusaded for the assault weapons ban, introduced and helped pass the law that eventually became Amber Alerts, ordered declassification of a role in the CIA's use of interrogation techniques, served as chair of Senate Intelligence Committee, and served as the top Democrat on the Judiciary Committee, the first woman in U.S. history to hold that particular position. Feinstein, of course, let me do that again. Feinstein, of course, ruffled many feathers along the way, including from the left as well as the right. As a ranking Democrat on the Judiciary Committee, she was criticized for the handling of Amy Coney Barrett's confirmation hearing, particularly when she hogged South Carolina Republican Senator Lindsey Graham for a job well done as the hearing came to a close. Democrats were so incensed by Feinstein that they faced calls for resignation from her own party. So, she has at times been controversial to people even on the left, including, as we noted, by an earlier assassination attempt by members of the left during an earlier part in her career. She stepped down from the role in the Judiciary Committee at the end of that year. In 2020, Feinstein also faced suggestions from colleagues that she was too old to serve, following interactions in which it was noted that she wasn't as sharp as she once was. In November 2022, Feinstein officially became the longest-serving woman U.S. senator, stating in a statement it was an incredible honor, saying it had been a great pleasure to watch more and more women walk the halls of the Senate. We went from having 2 women senators when I ran office for 1992 to 24 today, part of a continuing trend of women becoming more and more involved in the representative democracy. Feinstein, whose health, of course, has been declining over the last year or even arguably more, was absent from the Senate for months earlier this year, but resisted calls to resign before her term was up because it posed a whole bunch of political problems in terms of who would take her seat. The governor had said that they would appoint a different kind of person. Her own constituency wanted things. There was internal fights within the Democratic Party as to who would take that seat. So she was trying to, at least it seemed outwardly, let it be decided by an election, right, to avoid the problem. It's like, okay, I'm going to serve out my term. She had announced plans to retire from the Senate in 2024. So she's like, okay, rather than, resign and let the governor take the seat, which, might be a thing, let's just let this be decided by the people. But of course, with her death and the absence of the seat, one would assume the governor is going to make an appointment and thus bring some of those political issues among members of the Democratic Party to the forefront. Feinstein had married 3 times. In 1980, she married Richard Bloom, who she was with for 40 years until his death in 2022. Though Feinstein herself, of course, has now passed, her legacy will live on for quite some time. As Senator Alex Padilla said last month, it would be impossible to write a history of California politics, to write a history of American politics, without acknowledging Senator Feinstein, who set many firsts, both within her state and nationwide. So, being the first female senator to achieve so many firsts, being quite notable in her own right, running the Judiciary Committee, fighting the CIA, fighting other things, she will be noted, and her impact will be noted for quite some time. So she shaped and also her own party, of course, in California as well, has been largely shaped by her. So her impact will be felt for some time. Thus, that brings us to the end of the story about Senator Dianne Feinstein, who died at 90, not unexpectedly. Her health had been in serious decline for quite some time. notably getting shingles in March. And then, things got kind of progressively worse. And her health had also been a little bit temperamental at best, even before then. So at least for the last year, if not longer, her health has been in decline. And then, of course, the shingles happened and caused that health to become even more advancedly decelerating. And so that she's died, as a result of all that, which was not unexpected. Her death, of course, leaves open a seat for California in the Senate. And also her absence in the Senate changes the Senate majority, because now there's one less senator there. So until, she is replaced, the balance of power changes somewhat, because now there's one less Democrat to vote. So, she can't be there to vote. So the balance of power in the Senate changes as a result of her leaving. So there's that. It will somewhat increase Republican power, at least in the short term. So that should be interesting to see how that impacts the Senate. At least for the moment, that brings us to the end of discussion of this story. Change the background and push the button. Yeah. Appreciate it. All right. I'd like to thank this episode's sponsor today, wehearyou.com.au/uncivil. Do you ever just need someone to talk to? Sometimes we have those moments when life gets heavy and we just want to talk it out, but therapy can be expensive, and chatting with friends can come with judgment or expectations. Thus, the service, We Hear You, is here to help. These are professional listeners who know the value of a compassionate ear during challenging moments. Whenever you're feeling stressed, lonely, or just need a good vent, they're ready to hear you out and might even help you out with some advice and guidance if you wish. And today, Uncivil Law viewers can get 20% off your first call. To learn more or book your session, simply go to www.wehearyou.com.au/uncivil. The link is in the video description below and also on screen. So if you need someone to talk to, the service exists. I recommend going to their website and checking out and seeing whether wehearyou.com.au is right for you. And if it is, I hope that you will enjoy the 20% off your first call. So make sure to check them out, and we do appreciate their sponsorship. All right, how are all you doing today? I hope you're having a great day. It is a busy day in law world today. Many, many things happening today, some of which are unexpected. It is a busy day over there in law. So we will see what's going on. All right. Hope you're all having a great law day. Let's move to our next story, which caught me by surprise. I'm not going to lie. In surprising news to Uncivil, Donald Trump will not try to make his Georgia state RICO case into a federal case. This is quite surprising to me. I am somewhat shocked that they're not going to even try to change the Georgia case from state to federal. Of course, Mark Meadows lost his bid to do it, but Donald Trump, of course, had different arguments, namely and notably because he's not bound by the same political restraints that Meadows was in his job, right? The Hatch Act, which prohibits members of the federal government from acting in political ways, does not apply to the president. The president is exempt from the Hatch Act under the Act's own terms. So he had an argument that Meadows arguably didn't have, because he could be like, yeah, I was doing political things, and that doesn't necessarily inherently prevent it from being within his job function because he's not bound by the Hatch Act. But Donald Trump is not even going to try to take this case federal. So, color me shocked. Color me shocked. I can't even believe it. But that's apparently where we are. So let's learn a little bit more about this story. Former President Donald Trump will not seek to get his Georgia state RICO case turned into a federal case, according to his attorneys, in a filing on Thursday. 3 weeks after a federal judge rejected a similar attempt, although legally distinct attempt, by the White House chief of staff. So Mark Meadows lost his bid to take the state case federal, but Donald Trump had different arguments as the head of state and the head of government and the head of the executive branch, and the fact that he isn't bound by the Hatch Act. So he had a whole bunch of different arguments. It might have ultimately turned out the same, but he didn't even try, which seems odd. So, okay. The notice, which was filed in federal court in Atlanta, follows a September 8th decision by a U.S. district judge that the chief staff, Mark Meadows, had not even met the quite low threshold to move his case to federal court, which incidentally, by the way, was subject to appeal, although I don't know if Mark Meadows is appealing that, but one would imagine he will, because the judge could be wrong as a matter of law. And, even if the judge had ruled against Trump, he could have appealed that to the Court of Appeals for the 11th Circuit, and then, of course, could appeal that to the U.S. Supreme Court on the law. And so, Mark Meadows has lost for the moment, but it isn't necessarily to say Donald Trump would automatically lose because the case is different. Trump had, of course, pled not guilty to the charges, including Georgia's version of RICO, over his efforts to overturn the election, the 2020 election. He was indicted last month with Meadows and 17 others. The notice, filed in state court in Atlanta by Trump's defense attorney, expressed confidence in how Fulton County Superior Court Judge Scott McAfee will handle the trial, but may have also reflected difficulties that other defendants have had in trying to move their cases federal. But as I've noted, Donald Trump is in a somewhat unique position. He has arguments no one else has because he's the head of the executive branch, because he's the head of state, because he's the head of government, because he's not subject to the Hatch Act. He has arguments. He has constitutional arguments that are rooted directly in Article 2 that are not available to anyone else because he alone is the president. And that comes with some interesting ideas under the Constitution that, no one else can necessarily claim because everyone else is but the agent and he's the principal. So he necessarily has any argument anyone else would have. He has all of them combined. So everyone else has fractions of the argument. And those fractions may or not be successful, but in their combined form, it's a different legal game. President Trump now notifies the court that he will not seek to remove his case to federal court. The decision is based on his well-founded confidence that this honorable court intends to fully and completely protect his constitutional right to a fair trial and guarantee him due process of law throughout the prosecution of the case in Georgia. Okay. I have a tough time believing that on its face, to be quite honest. Of course, one of the big advantages in going federal is that you have a different jury because the jury is drawn from the federal district instead of just the county. So the Fulton County trial will be heard by the Fulton County jury of Fulton County. Fulton County is Atlanta, which, like many large cities, tends to lean more Democratic than more outlying areas of the state. So one of the biggest reasons to go federal was just for a different jury panel, because you would have gotten the entire Northern District of Georgia, which includes Fulton County, but is not limited to Fulton County. And so one would imagine it would increase the probability that you would get people who would be more amenable to Republican thought than Fulton County, which is Atlanta. So apparently we have every confidence in the jury of Fulton County. I have a tough time believing that on its face, to be quite honest, but that's what they've said on the record. So, okay. If Trump had gotten his case taken to federal court, he could have also tried to get charges dismissed altogether on the grounds of immunity that flows from the position of being president, which also that too, because he would have federal defenses. Those defenses may or may not work. They may or may not be granted, but now they're not even an option because he didn't go federal. He didn't seek the protection of the federal government. So if he had gone federal, in addition to getting a wider jury, which would have been nice, he also could have moved to dismiss the charges altogether on the grounds of immunity, which, that would also have to be heard on appeal before the case could be heard, because immunity is one of those issues that gets to be appealed before the case. So if his immunity had been denied, he would have a right to appeal and possibly go to the US Supreme Court on the issue. But now we're not doing that. I am confused. I don't understand this to be what's going on. It's odd. The venue change could have also broadened the jury pool. Yeah, beyond the overwhelmingly Democratic Fulton County, and also would have meant the trial would not be photographed or televised, as cameras are not allowed inside the courtroom. So maybe that's it. Maybe he wants it televised. So I guess you and I will absolutely be watching this together, live streamed every step of the way. So that's something to look forward to. Pencil that into your calendar. You better believe Uncivil Law is going to be covering this case every step of the way. So there's that. So mark your calendars, because that's happening now. A venue change would not have meant that Trump would have been able to issue a pardon, because any conviction would still happen under state law, which is true. It's a weird, bizarro world, but it's okay, right? The case is heard in federal court, but it's still a state case. I know it's a little weird, but that's how it rolls. So the conviction would ultimately be under state law. So even if it had been gone federal, and even if all the rest of it, and even if he had been convicted, he would not be able to issue a pardon to himself, because the conviction ultimately would be state, notwithstanding the fact it's heard in federal court. It's weird, but it's federal law. It's the way it's written. So, we just press on and take note. Several other defendants, of course, are also seeking to remove their cases to federal court, and the judge has not yet ruled on those cases. Meadows, somewhat surprisingly, decided to testify as part of his bid to remove his case. Others, of course, have not. Trump would not have been required to testify at the hearing. So, if the issue was, I didn't want to be put under oath because I want to maintain my right to remain silent, which, fair enough, then he didn't have to testify. He could have been done on the paper. And Trump's testimony in this context would be of little additional value on the law, because everything can be defined without his participation. You could even get Mark Meadows to testify for you, because as chief of staff for other people. So you wouldn't have to testify in your own right. If he had to decide to testify, that would give prosecutors a chance to cross-examine him. Anything he said would be able to be used at his eventual trial, which is a pretty good reason to keep your mouth shut. But, not really a good reason to not do this in the first place, because, maybe the judge would have said no, but you could have appealed that. So if the issue is I didn't want to testify in federal court, that wasn't required. So I don't know what we're doing here. Mark Meadows had asked for the charges to be dismissed, saying the Constitution made him immune from his role. The judge ruled the actions at the heart of the prosecution charges against Meadows were taken on behalf of the Trump campaign, with an ultimate goal of affecting state elections and procedures. Trump, who's facing 3 other criminal cases, so far been unsuccessful in seeking to have state cases taken federal in New York, which, I totally understand that decision from New York, because those cases out of New York, the Bragg cases, deal with Trump's business dealings. So the tie to him being president is thin at best and probably non-existent, because his business dealings are not part of his role of being president. So there's nothing that emerges as a result of him being president. So the fact that the New York case was unable to be taken federal didn't really surprise me in its decision. But this case obviously is quite different. He has also asked the federal appeal court to reverse the judge opinion, keeping the case in state court in the Bragg case, even though it's probably the correct decision in the Bragg case, but not taking the option here when the tie to his role as federal office is like half the case on point. So yeah. So, okay, that's weird. Thus, that brings us to a perhaps surprising conclusion about Trump not taking his bid federal. And that appears to be the end of that because there are time limits involved, and you have to invoke this within certain time periods. And so, he doesn't just get to magically change his mind later because the window to file is going to run out pretty soon, actually. I believe it's 60 days. I'd have to double check, but it's not that long a window, and the window's coming to an end pretty fast. So Donald Trump is in the use it or lose it position, and apparently is going with lose it. He doesn't even want to try taking it federal, which strikes me as very, very odd. Donald Trump might have lost the bid federally. That might even be the legally correct decision in the end. But the fact that you're not even going to try to take it federal when you've taken or tried to take other cases federal strikes me as really, really odd. I don't get it. But I guess we're going on TV, people. I guess we're going on TV with Trump on camera and the case being heard in court and all the rest of it. So welcome to the clown show, I guess. Get your tickets ready, people, because it's going to be an event. It's going to make the Johnny Depp trial look like a light soiree by the time we're done. I'm quite sure. Alpacas ain't nothing by the time we're done with this. Holy God. So we're going on camera, people in Georgia, and that's where we're sitting. And that brings us to the end of discussion of this story. Push the button. Button. Work button. Button. Push button. Yeah. I don't understand this. I don't get it. It doesn't make sense to Uncivil. Uncivil is deeply confused. I don't understand it. He might have well lost in the end, but why not even try? Because we trust the Fulton County court system and the Fulton County judge and the Fulton County jury? Really? If it's because he really, really wants to appear on camera, that might be the stupidest reason I've ever heard of. Which it might be the reason. I mean, it's the only reason that makes any sort of sense on any sort of level. He wants the camera. On the theory, I guess, that, the trial will be seen as him being done dirty. And people will be so outraged by him being done dirty, it will elevate him ever further in the polls and in the election. I guess. This is insane. This is cuckoo for Cocoa Puffs, cray cray. I don't think. Maybe he's trying to call the Fulton County DA's bluff? I don't know about that. She seems like she likes the camera too. You know, she wants to turn this into a bid for, you know, whatever she wants to turn this into a bid for. You know, and she's the one that brings down the Donald. It's going to do wonders for her career. She'll wind up being president by the time she's done. Holy God. We're going to have to get a tent. I don't know even what we're going to do in terms of streaming this. This is going to be weird. We're going to have to get press passes or something, and we're going to set up a tent. Maybe we'll set up a tent right outside the courthouse and stream it from the courthouse, I guess. Maybe we'll do that. We'll get a tent. We'll get a 10 by 10 tent and a desk and a very generous mobile streaming plan, I guess. And we'll do it live, maybe from the courthouse steps, I guess. This is different. You have connections in Atlanta? I may need them, Sandy. I may need them. I may need some connections in Atlanta. This is weird. This is weird. I don't understand what's happening right now. We may be doing an uncivil road trip. We may be doing uncivil road trip. I need to tell Nate about this right away. Excuse me, I need to text Nate right away. Let him know that the world just came to an end. Trump filed notice. He is not seeking to remove his Georgia RICO case to federal court. Looks like the streaming of the trial is on. Johnny Depp has nothing on this upcoming freak show. Will there be alpacas? I think alpacas will be the least strange thing about it by the time we're done. All right. Well, let's move into something else I kind of understand. How long do I anticipate the trial lasting? Weeks and weeks and weeks, I'm sure. Weeks and weeks and weeks, I'm sure. It will go on, let's say a month minimum. I would think. I don't know, but I'm going to guess. I'm going to guess it's going to go on for a month. Seems like a reasonable estimate. Does anyone know anyone in Atlanta, preferably near the Fulton County Courthouse, that has a room that I could have for like a month? So, yeah. Maybe longer. So someone talk to someone and let me know what's available. Okay, yeah. Yeah. Okay. If Donald Trump takes the stand, dude, if this is some sort of gambit, it is the worst gambit I've ever thought of in my life. So one of us is incredibly wrong. If this is some gambit on the idea that the corruption of the system will become apparent and the people will rise up against him and blah, blah, blah stuff. Dude, what happened this morning? The world came a little bit to an end this morning. Are we going to be able to watch the trial? You bet your sweet ass you will. Yeah. I'm going to get a 10 by 10 tent. I'm going to have to get a media pass. I may have someone have to run some errands for me and go down there in person and apply for a media pass or whatever so that I can stream from the sidewalk. I'm going to get myself a 10 by 10 tent and a laptop, and I'll take my camera down there. I'll take my mic down there. I'll take the whole setup down there and stream from a 10 by 10 tent on a sidewalk as, the show is, absolutely underway. It's going to be a thing. Great. Let's move on to something else, please, for the love of God. All right. In social media news, the Supreme Court has decided to hear twin cases from Florida and Texas relating to social media censorship and whether states can stop the social media censorship. We have covered this case before, principally the Texas case. We covered it in its case in the district level and also on the Court of Appeals level. And I thought, that the Texas law looked like it might actually withstand scrutiny. The Florida law had some problems in its way it was written. So they were both trying to do the same thing on some level, prevent social media companies from discriminating against viewpoint about who could, say what viewpoints. But Texas's was more cleverly drafted, at least in my opinion. And I thought the Fifth Circuit opinion might withstand scrutiny. Well, I guess we're going to find out now whether or not I was right. So it's because the Supreme Court has decided to take review of these cases on whether or not states can force social media companies to stop discriminating on the basis of political viewpoint. Can states do that, or is that a First Amendment violation? Okay, let's learn more. The Supreme Court on Friday agreed to take up cases originating from Texas and Florida that would regulate how large social media companies like Facebook and Twitter can control content posted on their sites. The laws were enacted in 2021 in response to the legislature's belief the companies were censoring users on the basis of viewpoint. The companies contend the laws violate their First Amendment rights. So that's sort of where we're sitting. On the one hand, the legislature says, okay, social media companies, it seems to us that you are taking action against people because of their protected viewpoints. And the social media companies say for their part, but we're not the government, and we have a First Amendment right too, both in freedom of association and also freedom of speech, and also freedom of press, I suppose, incidentally. So we could even make it a First Amendment trifecta, that we have some rights that enable us to not host content we don't like for whatever reason, including political viewpoint. So that's the fight, right? It's like, do the social media companies have to host this content? Do they have to transmit the content? And there is some case law that suggests the answer might be yes. Okay, so there is, the Fair Report Doctrine, which isn't the law anymore, but did exist for a time, that the Supreme Court upheld, incidentally, back in the 1980s, that at the time required broadcast TV to give equal time to different political candidates. So if you had the one political candidate on, you were required to have the other political candidate equal time. That was something that was upheld by the Supreme Court in the 1980s with respect to broadcast TV. And also there's some cases from as far back as the telegraph era dealing with states trying to force the then nascent Western Union Telegraph and forcing them to carry messages from providers they don't like. And Western Union saying we have a First Amendment right, and the court saying no, because you are merely the transmitting tool. You don't have a First Amendment right in the transmission. You're merely a courier, basically, in so many words. And so you don't have a First Amendment right because it's not your speech, Western Union. You may be the one transmitting it, but it's not you speaking. So it's not your First Amendment. And you're discriminating, and we have the right to, prevent that. And the courts upheld that too. So, that's part of the issue. And then, of course, you have Twitter and social media come along and say, okay, are you like a Western Union telegraph? Are you like a broadcast TV? Or are you like something else? So, yeah, it's a very interesting First Amendment case, to be sure. Yeah, we'll see how it goes. The announcement that the Supreme Court has decided to grant this case in the form of Moody versus NetChoice and NetChoice versus Paxton came as part of a list of orders. So NetChoice is suing in both cases. In one case, the decision was that it was unconstitutional. In the other case, the decision was it was constitutional. But there are reasons to believe both those things are true. Because Florida's law and Texas's law were not written the same. And so it is very possible that Florida's version of this was unconstitutional, but Texas's version is constitutional because of some material differences in how the statute was written. So the 11th Circuit said Florida's version is unconstitutional. The 5th Circuit said Texas's version is constitutional. They might both be right. We'll see as the Supreme Court decides to grant these twin cases for review. The Texas and Florida legislatures passed the laws at the center of the dispute in 2021. The Texas law, known as HB 20, bars social media platforms with at least 50 million active users from blocking, removing, or demonetizing content based on viewers' views. The Florida law, known as SB 1072, or the Stop Social Media Censorship Act, prohibits social media companies from banning political conduits and journalistic enterprises. So, yeah, technology companies went to federal court in Texas and Florida to challenge the laws, arguing, among other things, they violated the company's rights to the First Amendment because they say, well, first of all, we have a right to speak or not on our own terms, and you can't make us speak, and you can't make us not speak. That's in the nature of the First Amendment. You can't do that. Second of all, we have a freedom of association problem because you're forcing us to associate with people we don't want to associate with. And third of all, we have a freedom of press problem because we are a press, because we're a method of technological communication. And so they're like, okay, we have First Amendment rights times 3 that allow us to, prevent this from happening. The justices put on Texas's law on hold last year while challenges continued in lower courts. In an opinion joined by Justice Clarence Thomas and Neil Gorsuch, Samuel Alito suggested the court did not need to intervene yet. Kagan also indicated without explanation she would have allowed the law to go into effect. So you have 4 members of the court say, we are not so hot about this, but you only need 4 votes to hear the case. So you have 4 votes to hear the case, so we're going to do that. In September 2022, the U.S. Court of Appeals for the 5th Circuit ruled for Texas and upheld Texas's version of the law, and what I thought was a very smart decision. Reasonably, in my mind, analogizing social media like Twitter to the telegraph of old. You are just a telegraph with some minor tweaks, which isn't a wholly invalid analogy. Like the person comes to the telegraph counter with their message and you transmit the message. Or the person opens their app and types it out and hits send. Either way, you are a courier transmitting the message. In the case of the telegraph, typically to one recipient. In the case of social media, typically to many recipients. But what's the difference? You're just the courier. You have to make many stops as opposed to one stop, but you're just the courier. So, I thought that was a pretty reasonable analogy. It could break down, but I thought it was a pretty interesting case. This, of course, prompted tech companies to return to the Supreme Court asking the justices to weigh in. Texas agreed the court should grant review and urged the justices to consider both laws at the same time. So Texas is also like, yes, please take this up, even though we won. And also, please take up Florida's case as well. Florida, for its part, had come to the Supreme Court asking the justices to weigh in after the U.S. Court of Appeals for the 11th Circuit blocked Florida's version of the law. Texas version legal, Florida version illegal. In January, the justices had asked whether to take it up. In a brief filed in August, the U.S. Solicitor General recommended the court take up two questions presented by the case: whether the provisions in Texas and Florida laws that regulate tech companies' ability to remove, edit, or arrange the content appears on their platforms violates the First Amendment, as well as provisions that require tech companies to explain their decisions violate the First Amendment. The Solicitor General of the United States urges justice to strike down both sets of requirements, but told the justices there's no need for them to weigh in two other aspects of the dispute: the tech companies' challenges to provisions in Texas laws imposing general disclosure requirements on social media, and the argument that the laws were enacted to target large tech companies because of decisions regarding the conservative site. So maybe this was illegal because it was First Amendment retaliation, but then it gets into whose First Amendment is it? Who's the one speaking? So there was an idea that maybe these laws were retaliatory, but then maybe not, because maybe there's no First Amendment interest being violated in the first place because you're just couriers. And so, there's that. Among other things, she explained both sets of courts of appeals rejected these arguments, so there was no division on those particular issues. In an order list, the justices followed the Solicitor General's recommendation to take up the first two questions presented in the case, but not other issues. So we're just going to take up the issues in which there is a division of opinion between the two cases. The court will hear argument next year. The dispute is the second one involving social media this year. In April, the justices agreed to decide a separate issue as to whether public officials are acting as the government with respect to their social media accounts when they block people on their personal social media accounts. An issue that's also been percolating because then President Trump blocked some people, and the left went crazy saying, you can't block people because First Amendment. And then some of the people on the left blocked people, including Alexandria Ocasio-Cortez, who said, President Trump blocking people is illegal, it's unconstitutional. And then she blocked people, which is always hilarious. But there is a dispute as to whether or not these social media accounts are private or are they government. So are these accounts personal or not? So are these official communication channels or are these personal communication channels? So when they block people, are they blocking people personally or are they blocking people as the government? So the U.S. Supreme Court decided to hear that issue, which I'm sure will also be super duper fun. The Supreme Court taking up two cases that present that question in the form of O'Connor Ratliff versus Garner and Linkty versus Freed. So when, if ever, are personal social media accounts not so personal? That should be exciting to follow, I'm sure. The justices are also currently considering taking up a case, but have not yet acted on a case, a request from the Biden administration to block an order by a federal judge limiting communication between the White House and social media. There has been some allegations that the Biden administration and its various apparatuses, let's say, put pressure on social media to do things with respect to speech, which is a real problem. That the government might have improperly censored via private action, but because they were the one directing it, not so private. When the private social media company acts in concert with the government, suddenly, welcome, congratulations, you're now the government. So there's that problem. So the judge ordered that, there not be communication between the White House and the social media because they thought that there was a serious First Amendment problem. The Biden administration would like to continue their communications very much. White House district judge had ruled the federal government had engaged in a massive effort to suppress disfavored conservative speech. After the federal court agreed with the conclusion, it somewhat narrowed the scope of the order, but not completely, and Biden has asked the Supreme Court to intervene because we'd like to continue talking to the social media companies in an unrestricted way, having them do our bidding and it not be state action. So the Supreme Court is also deciding whether or not to take that case up, which if they do, that should be exciting as well. Thus, that brings us to the end of consideration for the moment about the Supreme Court taking up cases that we've followed in the past, particularly as it relates to Texas's version of the thing, a little bit less so with Florida's version of the thing. In the case, both states, to some degree and via some mechanisms, although the exact nature of the degree and mechanisms is part of the problem, they said various versions of social media companies, you can't discriminate against people because of their viewpoint. You must host the speech of people with the different political viewpoints. And the 11th Circuit said Florida's version was illegal. And the 5th Circuit said Texas's version was legal, both of which might quite possibly be correct. Those are quite possibly both correct decisions. But we're going to find out for sure, I guess, because the U.S. Supreme Court has decided to hear these cases as to whose speech is it, for starters, and can the states impose these requirements, at least some version of them, on the social media companies and force them to host, platform, transmit, or otherwise distribute speech that they might not themselves personally agree with. So that's happening, and we'll see how those cases resolve in the near future. At least for the moment, that brings us to the end of discussion of this story. Change the background. Push the button. Push the button. Yeah. We have a heavy law day, guys. A lot of stuff is happening. A lot of stuff is happening. It is a law-intensive day. There should be a love button. If you're on mobile, there's like the little like react things. You can press the hearts on mobile if you like. All right. There's always something happening every day, but some days I have to dig a little deeper for law stories. So some days I have to dig a little deeper. This was not one of those days. Sometimes I have to look a little harder for some law stories. Apparently everything decided to happen yesterday. So that was good. All right, let's continue this. Emily has a love button. I have a little heart you can press. Hearts are nice. Ruger, grow up. Grow up. All right, let's cover this. In disgraced FBI officials deciding to fight back because they didn't do nothing wrong by conspiring to say that Trump should never be president, Peter Strzok and Lisa Page are going to grill Trump about the texts they sent that ended their careers. So you'll remember Peter Strzok and Lisa Page, I'm sure, two people at the FBI who were sending messages amongst themselves saying, Trump should never be president. We will stop it. We will prevent Trump from being president, whatever it takes, suggesting a conspiracy. And they were fired by the FBI. Well, they think that they were improperly fired because they engaged in protected First Amendment speech by saying that they should conspire to prevent Trump from being president. So they are suing, and Trump is going to be deposed about this. So that should be fun and exciting. Let's learn a little bit more about Peter Strzok and Lisa Page. Lawyers for former FBI lawyer Lisa Page and fired FBI agent Peter Strzok have scheduled a deposition for Donald Trump to testify in a witness against their lawsuits against the Department of Justice for firing them. You were wrong to fire me. You shouldn't have fired me. And Donald Trump was the head of the Department of Justice, so we'd like to depose him too. Strzok and Page, who were having an affair at the time, were both involved in investigations relating to Hillary Clinton's private server and also involved in special counsel Robert Mueller's probe of Trump and his associates, are suing the DOJ over release of the anti-Trump text messages they sent to each other in 2015 and 2016, texts of which ultimately led to a public shaming and end of their careers. Hey, Department of Justice, you were wrong to release those text messages out into the open that showed we were trying to engage in a conspiracy to prevent someone from being president. You were wrong to expose our text messages showing the conspiracy. We're going to sue you for exposing our text messages and sue you for improperly firing us on the basis of the text messages. I suppose further evidence of the idea that a good defense is the same thing as a good offense, I guess. Page, for her part, resigned from the FBI, alleges in her lawsuit that the release of text violates her privacy rights. This was an improper invasion of my privacy. Strzok, who was fired from the FBI, also alleges the privacy violations and also argues wrongful termination for protected speech in violation of the First Amendment and claimed his Fifth Amendment right to due process is violated. So he's like, I have a property interest in my job, and you improperly fired me. You didn't go through all the steps to fire me. So you violated my right to due process by firing me. And also you fired me for protected First Amendment reasons because I was allowed to send a message to someone else working within the Department of Justice saying we should conspire to prevent Trump from becoming president. That would be a good thing for us to do. I have a private interest in those text messages, Page and Strzok say. Okay. While Trump himself is not a defendant in the lawsuit, the plaintiffs maintain the former president's testimony about his role in influencing the ouster makes him worthy of deposition because he's really the one that caused the Department of Justice to fire them. And so it might be the Department of Justice that fired them, but he's the one who is pulling the strings, which, as the president of the United States, he does get the ability to somewhat control the Department of Justice because the Department of Justice reports to the Attorney General and the Attorney General reports to the president. So there's that. It's worthy of noting, of course, this is a distinction among states, by the way, because it is often, although not always true, in state systems, the Attorney General is independently elected. So in many states, the Attorney General does not answer to the governor. So that analogy would break down on the state level. But of course, in the federal system, they are appointed by the president. And it is the president's Department of Justice. So there's a bit of distinction there on state law, just as long as we're trying to learn something legally. In early September, an appellate court agreed that Trump could be deposed for 2 hours on a narrow set of topics, despite objections raised by the Biden administration, DOJ, that the DC Circuit and virtually every other court of appeals has recognized that subjecting high-level government officials, to say nothing of former presidents, to oral deposition is not currently normally countenanced, because the Biden doesn't want the precedent either, because he doesn't really want to be deposed someday about things going on in his Department of Justice or his FBI. So, perhaps thinking ahead a little bit and saying, I don't really want to be on the deposition table either. The Biden administration said that this should not go forward. And incidentally, they're not wrong on the law, right? There is a general presumption that high-level officials are not to be deposed on these kinds of issues because they're not personally responsible, and it's merely a tool to harass and get at the high-level official for the sake of it. So typically, you don't get to depose the head of the business or the head of the agency or the head of whatever unless you can show they had personal involvement. The mere fact that they are the ultimate head is not sufficient to depose them. So that is typically the rule, but not the rule here, because apparently, Trump said some stuff that they thought made him personally available. So, okay. The civil case deposition is currently scheduled to occur October 17th. Also, there's issues about a possible governmental shutdown, as I'm sure some of you who have been paying attention to the news have noted, and they are concerned how that might throw a wrench in the plans. Plaintiff recognized the government shutdown appears likely to commence October 1st, and the Department of Justice may request stays in nearly all civil actions to which it's a party. Plaintiffs are also aware of the possibility of a district-wide default stay in such cases, considering lengthy efforts that scheduling the deposition require, because Trump is also busy with some other matters, as you might have noticed, and that a stay might result in substantial delay. Plaintiffs will oppose any stay and expecting prompt relief. So they don't want any sort of government default to interfere with their depositions, but, probably will. So, they'd like it not to, but it will. So, there is a world beyond them, as they're just beginning to learn, apparently. Thus, that brings us to the end of the story about Peter Strzok and Lisa Page. Pictured here, two officials within the Department of Justice, one a lawyer, one an FBI agent, who sent text messages to each other, essentially saying, wouldn't it be fun to conspire to prevent Trump from being president? Yes, that sounds like fun. I would like to conspire with you to prevent Trump from being president. He sucks. We should use our power as FBI officials and lawyers for the DOJ to prevent Trump from being president. Wouldn't that be a fun thing to do? And then they were involved in the Mueller probe. And then they were involved in the server thing with Hillary Clinton, and may potentially have used their offices in somewhat inappropriate ways to potentially benefit their political friends and harm their political enemies. And they were fired, and they'd like their jobs back because they were improperly fired. And also, this is First Amendment retaliation. And also, you violated their privacy by making their text messages public. So all those things, apparently. So that is happening, at least for the moment. That brings us to end discussion of this case. Change the background. Push the button. Yeah. Button works. When button works, I cheer. Too many lawsuits happening. Please stop doing new law things. I'm desperately trying to catch up. By the way, just as a program note, because I haven't mentioned it during this stream, the interview with Tony Busby is still on. It's now on for Monday. So those of you who may have remembered that we were supposed to do an interview with Tony Busby at 11 a.m. today, not so much. Tony Busby had to reschedule for Monday, which, he's a very busy lawyer. And so it may get rescheduled, and it may get rescheduled again. Who knows? We obviously have to do a little bit to accommodate him, which is, not much of a problem because this is my full-time job. So my ability to accommodate him is pretty flexible. So we will endeavor to do that. So not so much with the Tony Busby interview today, now scheduled for 1 p.m. on Monday. So just FYI. Tony P gives $9.99 to say, because I can't gift memberships from my phone, Kurt is the best. Yeah, I'm not sure what the gifting memberships thing from the phone is all about, but that's where we're at. I am looking forward to the interview. He's an interesting guy. He's led a very rich career. Former Marine recon officer. He's had many different lawsuits. Represented Jimmy Buffett at one point, which is kind of cool. Just, incidentally, to prevent trademark infringement. Has gotten involved himself in lawsuits, I think, in every single state. He's gotten around a little bit. He's a notable person. Also had some controversy in his life, but, when you're that busy and that big, people are going to have some thoughts as it concerns you. So he's a little bit my hero. He probably also bills at like $1,000 an hour. So this interview is costing him $500. So, because if we talk for a half hour, right? I mean, he could be billing that time, but he's not. So we appreciate his time. Thank you, KL Burke, for the 20 gift memberships. And thank you, Sandy, as always, for the gift memberships. They are extensively appreciated. I like his aggressive style. And I also like the fact that he's obviously well prepped, which I appreciate. Which, every lawyer should be, but not every lawyer always does. But he's well prepped. Like he knows everything. He knows the file. He knows it basically cold. He knows where he knows the answer to every question, and he knows where the answer is. He knows exactly where it is. So if the person doesn't give him the right answer, he's able to be like, okay, let us consult, exhibit number so-and-so, page so-and-so, paragraph so-and-so. Would you like to read it out for us, please? Nothing magic there, just a little bit of grease work. But I appreciate that. And I appreciate his sardonic questioning style. And his prep. He definitely gave a warm spot in my heart during the whole Paxton impeachment trial. Whatever can be said for, the Paxton impeachment trial, I and this isn't contradicting anything I said earlier for anyone who's paying attention, but Paxton's lawyers were on the whole better than the House's lawyers, not for the least of reasons that Rusty, at least in my humble opinion, was not very good and wasted a lot of time that could have been used much more efficiently and left some things on the table that didn't have to be left on the table. And so they were much more efficient, on point, and prepped on Paxton's side of the table. Yeah. So, I always recognize good lawyering for what it is, and they had good lawyering. They were able to particularly well demolish Mr. Muir, wasn't it? The first witness, the former first AG, with that brutal question of it wasn't your dream job to be a federal judge? And I was like, oh, I feel that pain. I didn't want to be a federal judge. I have my dream job. I work for First Liberty. That's my dream job. Uh-huh. So it wasn't disappointing to you when you were nominated to be a federal judge and then they upheld your nomination and then the president withdrew your nomination? That wasn't hurtful to you? No, I like my job. I like everything I do. Oof. Yeah, I don't really believe you, sir. I don't really believe you. And as I pointed out, you can always turn down a nomination, and people sometimes do. Sometimes people do turn down nominations to be a federal judge. It's usually a very significant pay cut for most people. And also the job may not necessarily be to everyone's liking, which I can totally understand. As a federal trial judge in particular, I can understand not wanting that particular job. It's first of all, I'm getting paid more. Second of all, I like what I'm doing more, so I'm going to say no. And not for nothing, sometimes federal judges leave the bench and go do things other than that because, one, they're getting paid more, and two, they like it more. So it happens. People say no sometimes. He didn't say no. He didn't say no, Donald Trump, I really appreciate that nomination and all. I appreciate you thinking of me, but it's just not for me. I have other dreams. I have other aspirations in my life. Being a federal judge sucks. He didn't say that. He apparently said, oh boy, please nominate me. I like it. And then it's like, it's okay. I didn't want it anyway. Yeah. I'd much rather be a federal court of appeals judge than a federal trial judge. I could imagine federal trial judge getting a little taxing at times, potentially. Dealing with all the minutia and everything as you play referee. And sometimes playing referee can be a little annoying sometimes when the kids aren't playing nice. So I could imagine that being a little trying at times. I'd much rather be a court of appeals judge than a trial judge. Because in an appeals land, I just get to deal with the law, and I don't even have to see the parties. It's great, right? Whoever the fighting children are, I don't even have to see them. They don't show up at appellate court. Their lawyers do. I don't have to see them or think about them, or, I can just go on the law on the briefs. It's fantastic. And not worry about their petty factual squabbles because that was dealt by someone else and just deal on the law. It's fantastic. Uncivil law for Court of Appeals, please. The law kicks ass. All right, let's press on. It's one of the reasons also I might want to be an appellate lawyer. The greatest job ever, right? I don't necessarily even have to see the client. At least hypothetically, I could run, one of the reasons as an appellate lawyer, I'm kind of attracted to it. It's like, I don't have to see the client. We don't have to talk. We don't have to interface. We don't have to interact. Send me money, send me a copy of the file, and I'll let you know how it turns out on the other side. Good times. All right, let's press on. For today's U.S. Supreme Court coverage, we do a preview of a case in which the Supreme Court is weighing who has the power to raise ADA complaints, and by extension, who has the power to raise complaints in general. So this deals with people who are raising complaints because they're basically testers. And this is the thing that exists a lot in California, although it exists mostly as a function of California specific law. So it's a little bit off point there, but there are people, because California says they can, they're private attorneys general, that go around and see whether or not people are compliant with such things like the ADA, the Americans with Disability Act. And if they're not, they sue on behalf of the state, which they're allowed to do because California law allows it. And this is somewhat similar. These are people that are testers. They create lawsuits not because they really are, in some sense, an injured party. They manufacture the case. And the idea of manufactured cases, by the way, is not like a novel concept either. Many of the great cases in history were manufactured. They were constructed. They were invented, in order to go through the process. So that's nothing new. But the Supreme Court is considering the degree to which these testers can bring these claims. And so let's learn a little bit more about this and how it might change the law as it relates to manufactured cases. Let's learn a little bit more about this. The U.S. Supreme Court is scheduled to hear arguments in the case of Ashen Hotels versus Laufer. In this upcoming week, the Supreme Court is set to consider the case that could alter the rights of people with disabilities to sue under the ADA, and also incidentally, by sort of transitive law, the ability of people to sue kind of for anything. So this basically is this is basically trying to decide who really does have a case or controversy. That's sort of what this is at the root of. So this is not really an ADA issue. This is more fundamental than that. This is more about who has standing on a fundamental level to bring this case. So this is being heard via the ADA, but this isn't really at its core an ADA case. This is more fundamental than that. It has to deal with standing and whether testers have standing. So that is really what the case is dealing with. The High Court will hear the oral arguments. The case was brought by Deborah Laufer, who is a Florida resident who has vision impairment and uses a cane or wheelchair. So Deborah Laufer is in fact a person who has disabilities. Fine. She sued Ascension Hotels, claiming that the website of Coast Village Inn and Cottages in Wells, Maine did not have adequate information about disability as required under ADA. So she's completely right about that part of it, right? The website is required by law to have information about disability accommodations under the Americans with Disability Act. It's a thing that the websites must have. She also appears to be right in fact that the website did not have this information. So she's correct on those facts. They're required to have it. They didn't have it. But the thing that's bringing this to issue is that Laufer is considered to be a tester, someone who actively looks for these things. She has filed over 600 lawsuits since 2018, making allegations against hotel owners and operators similar to the ones she brought against this hotel. So she is a person who is looking for websites that are not compliant and then suing, saying they're not compliant. You know, I'm a person with disability. You don't have the information I need. You know, that you're a problem. The lower court dismissed the matter, however, finding that Laufer was not an injured party because they had no plans in fact to visit the hotel. So that's sort of the critical thing, right? There's no injury to you. Yes, the websites are required to have the information. Yes, they don't have the information, but you personally were not planning on actually visiting this hotel. You know, it wasn't something that you were planning to do. You know, you weren't like looking for hotels in the area, and you know, you stumbled on this website as you were looking for hotels because you were visiting the area, and you found that this was not compliant, and so that was a problem. You know, this was not, you weren't looking for the website because you were trying to, you know, create a vacation in the area or, you know, a business trip in the area. You were just looking for websites that are not compliant. So the idea is that there's no injury to her. This decision was overturned by the Court of Appeals for the First Circuit, which determined Laura's feelings of frustration, humiliation, and second-class status were downstream consequences and adverse effects of informational injury. So they're saying that there's enough injury in the fact that the information itself was wrong, which seems somewhat legally questionable, to be fair. So, you know, that seems like a bit of a shaky theory. So it's like, yeah, you can't just be a tester. You can be a tester, you know, if you have a genuine desire to do something, but you don't have a genuine desire to do this. So you were trying to just, you know, manufacture lawsuits, even though you had no intent to stay there. So not enough standing is the idea. The cases come as more and more serial testers have emerged in recent years, and lower courts have differed on whether or not these people have standing. Businesses groups, including the Chamber of Commerce, American Hotel and Lodging, and Retail Litigation Center, have lined up behind the hotels, arguing that the testers are just taking advantage of small businesses because they're not actual customers. If they were actually customers, if they actually went to the business with the intent to be customer, and they found discrimination, that would be sufficient, right? If they genuinely walked into the door, as it were, virtually or otherwise, and found the business was not in compliance, then they would have standing because they're a genuine customer, or at least they were a prospective genuine customer, which is enough, right? You don't actually have to buy something. If you are a prospective customer, but a genuine one, and you find a breach, you know, that's enough. But the problem is here, these are not genuine prospective customers. They didn't have any intention of staying in any hotel in the area. They were just simply looking for a reason to sue. Disability advocates, for their part, say testers provide an invaluable service by ensuring businesses are following through on obligation. Okay, by the way, this is the part of the experience when I get real meta and in my own head, because I've just explained the same thing like 3 or 4 times. And sometimes people say, why do you repeat yourself so much? And one of the reasons I do it is because I question sometimes whether or not people hear it the first time, because sometimes people ask questions on videos and I'm like, I said something. So sometimes when it's really important, I'll say the same thing basically over and over again. So this is now like the 4th time me explaining the concept. Is it too much? Is it too little? Is it annoying? Is it good? I want to be a good uncivil. I feel like I have to explain it. I feel like I have to over-explain it. But I'm open to critique. Constructive critique. A legal director for Disability Rights and Education's Defense Fund, as quoted as saying, by speeding up the pace of compliance, testers bring the ADA's still unfilled promise closer to fruition. They have filed a friend of the court brief, an amicus, arguing that disabled people face discrimination barriers and policies every day, multiple times a year, 33 years after the ADA was enacted. It is true, unfortunately, that even 30 years after this law came to effect, businesses are not necessarily very good about following it all the time. So that is unfortunately true. They are not wrong. If individuals with the fortitude to take on the burden of enforcement as testers are stripped of standing, the result will undoubtedly be less private enforcement, frustration of statutory goals, and the continued exclusion of people with disabilities from community life, which, may be downstream consequences to be sure, but if they don't have standing, they don't have standing. Congress, incidentally, could presumably give them standing. They could give them power as private attorneys general to bring the lawsuit on behalf of the U.S. government. Not something the U.S. government does as much, but it does do it occasionally. Other states like California, as I've noted, have done it extensively as a matter of their own state law. So the federal government could create standing by giving them power to sue on behalf of the federal government, but they haven't done that, and so they may not have power to simply bring testers because they're trying to enforce something privately rather than on behalf of the government, right? So they can't file a complaint basically on behalf of citizens at large because they don't have the right to act in the name of the government. They only have the right to act in their own name, and if they themselves haven't been harmed, then they have a problem. In somewhat dramatic turn of events as it relates to this particular case and the history of the case, Laufer was forced to drop her claims against the hotel in July after an attorney who represented her in other case was disciplined by federal court. So not great, right? So yeah, that's somewhat of a dramatic turn. She was forced to drop the claim against the hotel because her attorney was disciplined for attorney malpractice. So not great. At the time, she asked the Supreme Court to dismiss the case as moot, but the justices said no. They would consider the issue further when it's heard. So they don't dismiss it as moot, although they could still decide it is moot. So they're going to hold oral arguments on it. So the mootness has not stopped them from moving forward. So she's like, you should not hear the case because I've dropped my claims. And the Supreme Court's all like, nah, we're going to hear it anyway. Which, okay. I mean, all right. And then the Supreme Court will have to decide whether or not the whole thing is moot as part of their discussion. So look for a dig, dismissed as improvidently granted in your future, I guess. We'll see. Thus, that brings us to the end of consideration for the moment about this complaint. Let me try that again. Me, me, me. Me, 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 me. Me, 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 me. Thus, that brings us to the end of the case for the moment about the Supreme Court hearing oral arguments on what it takes to have standing with respect to ADA complaints and also via transitive properties, kind of more globally than that. So this case ostensibly deals with the Americans with Disability Act, but in the end, it's not really about the Americans with Disability Act. That's just sort of the vehicle that's getting us there. The more primal issue is, what does it take to have standing, and can testers have standing when they are not, otherwise harmed, because they themselves didn't try to take advantage of the law as sort of a natural consequence of them looking to do a thing Like if they had decided to try to stay in the area and then found it, then fine. But that wasn't what was going on. So do these people have standing? So the standing issues continue to be heard by the Supreme Court on who can or cannot bring cases because who has or has not been injured. But the whole thing might be dismissed as improvidently granted because the case might be moot because she was forced to drop her claims. But the case for the moment is proceeding. So we'll see. At least for a moment, that brings us to the end of the discussion of this case. Change the background and push the button. Push the button. Yeah. All right. Good morning, uncivilians. Good morning to the 179 of you currently here with me. I thank each and every one of you for being part of this channel and this channel's experience. Yesterday, this channel crossed a milestone. 2,500 total videos posted to this channel. That's a lot of videos. I'm just saying, that's a lot of videos. If it takes 10,000 hours to be good at something, I have long past since exceeded that. So, okay, I've posted 2,500 videos and there's no end in sight. So that's an accomplishment, I guess. I'm not sure how to feel about that particular benchmark, to be honest. But that's where we're at, 2,500 videos. I'm not sure how many videos all of LawTube has combined, but yeah, it may not be 2,500. I'm not sure. I suppose it depends who you count as being part of LawTube when you're doing the numbers. But it's a lot. So, yeah. Let's just say that I have a significant fraction of the videos of all of LawTube. I'm a one-man show over here. What percentage of all of LawTube am I at this point? That's a good question. Is it 50%? It depends who you count on this equation, but yeah. Let's do another one. Uncivil Law is LawTube. LawTube just hasn't figured it out yet. That's all right. Let's cover a news story. In burger flipping pays better than you thought news, the California governor has signed a law that raises the minimum wage for fast food workers to $20 per hour. Yes, you too can earn $20 per hour at McDonald's or Burger King or Wendy's. $20 an hour minimum wage for fast food workers in the great state of California. Well, I guess that college degree isn't as needed as it once was. So, you know, that's notable. Let's read more about this coverage. Legal has 500 videos. Yeah, Legal's not part of LawTube. California's fast food workers will be paid at least $20 per hour next year under the law signed by Governor Newsom. When it takes effect on April 1st, not an April Fool's Day joke, unfortunately, fast food workers in California will have among the highest wages in the country, according to data completed by the University of California. The state's minimum wage for all other workers is $15.50 an hour. So you actually get paid more being a fast food worker than the minimum wage. So it's actually better to be a burger worker than working at, say, for example, like a Walmart or a Target or something. So $15.50 if you work retail somewhere, $20 to flip the burger at Walmart. Okay, that's where we're at. Cheering fast food worker and labor leaders gathered around Newsom as he signed the bill saying, quote, "This is a big deal." It certainly is. And I imagine will be somewhat reflected in the prices of fast food options in California. Just guessing, these increased labor costs might show up on the menu. Newsom's signature on Thursday reflects the power and influence of labor unions in California, which have organized fast food workers in an attempt to improve wages and working conditions. It also settles, for now at least, a fight between labor and business over how to regulate the industry. In exchange for the higher pay, labor unions dropped their attempt to make fast food corporations liable for misdeeds of independent franchise operators in California, an action that could have upended the business model in which the industry is based. Which, okay. So independent franchise is not necessarily fully independent, which, makes sense, at least in principle. Like what businesses are independent and are not is somewhat a matter of law. And so simply trying to say this business is not mine, it's independent, when they have your brand name and they use your menu and they use, your uniforms and use everything else. It's like California was saying, we're not sure how independent you really are. And so they were trying to increase liability, which does already exist to some degree, incidentally, for the parent corporation, regardless of the independent status. But they were trying to increase that to make them even increasingly liable, but they have dropped that request as part of the negotiations. The industry, meanwhile, has agreed to put a referendum related to workers' wages off the 2024 ballot. So they're just going to do this as an agreement rather than do it as a referendum. A person who works at Jack in the Box in Southern California says, "This is for my ancestors. This is for all the farm workers, all the cotton pickers. This is for them. We ride on our shoulders." That's an interesting perspective, to be sure, about how you gain $20 an hour is for your ancestors, the farm workers and cotton pickers. Also, it's California, I'll note, not the Deep South when it comes to the cotton, but I digress. California's fast food workers currently earn an average of $16.60 an hour, which is just over $34,000 a year. That is below the California poverty measure for a family of four. But then again, it's just the one person working. So if you try to support one person, or you try to support four people on one salary, it's not going to go as far. In California, most fast food workers are over 18 and are the main provider for their family, according to the University of California. The $20 minimum wage is, however, seen as just a starting point. The law creates a fast food council that has the power to increase the wage each year through 2029 by either 3.5% or the change in prices on the consumer price index, whichever is lower. So the $20 minimum wage will be increased every year for 6 years to keep up with the consumer price index, or 3.5%. So that job will continue to pay more and more. The raise takes effect on April the 1st and applies to workers at restaurants with 60 locations nationwide, with the exception for restaurants that make and sell their own bread, like Panera Bread, for some reason. McDonald's looking into making their own bread for their buns, potentially as we speak, I guess. Now the focus will shift to another group of low-wage workers with their own minimum wage increase. Lawmakers separately passed a bill earlier this month that would gradually raise the wage for healthcare workers to $25 an hour over the next decade. That raise won't apply to doctors and nurses, of course, because they typically work on salary, not wage, but to most everyone else who works at the hospital, for example, clinics or other healthcare facilities. So, the people in the healthcare deserve $25 an hour, so I guess you're worth at least 25% more than a fast food worker, I guess, is the idea. But unlike the fast food wage increases, which Newsom helped to negotiate, the governor has not said if he'd sign the raise for the healthcare workers, an issue being complicated by the state's Medicaid program, which is the main source of revenue for the hospital, because it would actually cost California more. So Newsom is less thrilled with the wage increases when it comes out of California's pocket, because many of the healthcare workers are paid by Medicaid, which is a state because many of the healthcare workers are paid out of state Medicaid, which is funded by the state government. That minimum wage comes directly out of California's budget. California also notably already in deficit in their budget. So when California itself has to directly pay for it, whoa, all of a sudden, we're not so in favor of that because it's coming out of our budget. It's amazing how those things work, right? When you have to pay for something, suddenly you're a lot less in favor of it. Wow, amazing. Labor unions, for their part, say that there's a study that says the costs would be offset by a reduction in the number of people relying on publicly funded assistance programs. But if you believe that, I have a Golden Gate Bridge to sell you. Yeah, if we increase wages, less people will use them, so it will balance itself out. Sure it will. Okay, yeah, let's wrap this story up. Thus, that brings us to the end of the story about Gavin Newsom signing a law that raises the California minimum wage for the burger flippers to $20 an hour, but is having second thoughts about a bill to raise the minimum wage to $25 an hour for the healthcare workers, because at least part of that would come directly out of California's budget. And whoa, suddenly this is an expense item, and I don't want to pay for that. California already has enough problems as it is spending for things. It's already spending too much. So, those healthcare workers, well, do they deserve $25 an hour? Not if I have to pay for it, but, if only the consumer has to pay for it, not a problem. So we'll see how this increases the fast food prices in California and how it also speeds automation along, one would imagine, as the automation looks increasingly more attractive by price comparison. So we may hire fewer workers and rely even more on automation. So pricing the workers potentially out of jobs altogether over here in California. But what else is new? Because they don't seem to understand basic economics, at least for the moment. That brings us to the end of discussion of this story. Thank you, Pretty Honest Throwaway, for your super chat. I feel bad, homeless people. Seems like it will be impossible for them to get a burger going forward. Thought fast food was supposed to be affordable. Preach. Change the background and push the button. Yeah, subtle change on that one, but it did change. All right. Thank you for the 181 of you who are still with us. I hope you're enjoying today's stream. We love it. We also love all the people who help to support gift memberships. Make sure that you've enabled gift memberships so that you get one, because we do have some pretty generous people on here when it comes to the gift memberships, and we want to make sure that you've enabled that option. So do that, please. And also, help buy a gift membership or two. That's also nice. They're only 99 cents a month. It's cheaper than buying a burger in California. So, Lynn Britton has been a member for 3 months. Thank you very much. Okay. Just a little break. Let's stretch together. Tilt our head to the right. And tilt her head to the left. Stretch out those neck muscles. Put her head around. Work those muscles a little bit. Go the other way. Ah, that was nice. All right, let's do a new story. In left-leaning people having a change of mind when the bill comes due news, New York City lawmakers are looking at a rollback of a climate change law because, whoa, suddenly people realized all those things were expensive and they don't like to pay for it. People are really in favor of laws that help to stop climate change until, they realize that there's expenses and they're going to have to pay for them. So the lawmakers passed all these wonderful climate change laws. Hooray, climate. Oh, wait, what a second? It's going to cost money. It's going to cost money. Oh, okay. Maybe we should have a second look at that. Not that all those costs weren't entirely predictable in advance, by the way, if you've been paying attention. It's not exactly a surprise, but apparently a surprise to them for some reason. Let's take a look at this story. New York City lawmakers are pushing against legislation that would roll back strict requirements under a new climate change law for buildings covering 800,000 co-op and condo apartments, citing costs that could have their homeowners seeing red. So wait a second, we're about to pass a law that would cause 800,000 people's bill to radically increase. Maybe we should have another look at it. The local law, also known as the Climate Mobilization Emissions Law of 2019, set limits on greenhouse gas emissions of building starting next year to help New York City reach the goal of a 40% reduction by the year 2030 and an 80% reduction in the city by calendar year 2050. So they passed this law in 2019 saying, okay, in 2024, we're going to start having this thing come into effect. And wait a second, I can't help noticing it's September 2023. The future finally came. They're going to have to start doing this. And this is expensive. People were all in favor of it, and now the bill's coming due, and they're like, wait a second, this is going to cost us a lot of money. The bill, the local law rather, requires buildings with more than 25,000 square feet to replace their old heating oil and natural gas boilers and to switch to electric heat so as to cut down on greenhouse gas emissions. The city law covers existing buildings, which amount for 2/3 of the emissions that they say in the city. So you got to renovate all those buildings. You got to tear out your heating oil and natural gas boilers and put in electric heat, among other things, for 800,000 buildings. And you got to pay for it. So yeah. The proposed easing of the green regulations comes just days after New York major business group launched a $1 million campaign to push the governor and state lawmakers to ease state anti-pollution laws tackling climate change, arguing the regulations are too costly to both them and the consumer who actually has to pay for all this. What? We have to pay for all that green energy? I just thought it was magic unicorns that came from the sky. Yeah. The Queens Democratic Council member, Linda Lee and Sarah Ung, have said the bill makes necessary revisions to make it easier for business owners to comply with the law without punishing apartment owners, saying Local Law 97 current structure unintentionally jeopardizes the housing stability of many working and middle-class condo and co-op owners. Whoa, that New York City law, it's going to hurt the poor. It's going to hurt the poor by causing them to spend so much to rip out systems that are working and put in new systems at, considerable expense. This is bad, they say. Our forthcoming bill will provide necessary adjustments, acknowledging past efforts of many co-ops and condos to reduce emissions and their use of open spaces to mitigate environmental impacts. The city councilman saying, quote, the bill signifies the start of a more inclusive process that recognizes personal stakes many homeowners have in the legislation. The sustainability of our city and financial security of our residents are not mutually exclusive, as they want to have their cake and eat it too. The new proposed bill, which will solve all the problems, I'm sure, if approved, would take into consideration open and green spaces as part of a building's gross floor area when calculating emission limits, make it easier to comply with the law. So if you have green spaces, then we factor those in because they're not producing emissions. So the rest of the building doesn't have to be as environmentally friendly. Eases annual gas house limits if buildings have made prior retrofits, such as oil to gas conversions or the installation of solar panels. So, we'll give you a break if you've already done retrofits in the past, even though they're not the new fancy retrofits that we like. Roll back penalties for buildings with an average assessed value of $65,000 or less. Mandate courts to regard the median property value of units in the building as a factor when imposing penalties. The group representing co-op and condos raised a warning flag about the potentially steep green costs in the spring, launching TV, digital, and mailing campaigns in 18 districts across the city saying, quote, "We're not looking to dismiss Local Law 97, heaven forbid, but refine it. Many homeowners are under pressure to meet the city's sustainability mandates. The new legislation seeks a middle ground that upholds both environmental goals and homeowners' economic well-being as we try to avoid the consequences of our own Green New Deal." The mayor's office, for their part, had no immediate comment on the proposed bill, but 2 weeks ago, they said they strongly backed the green emissions reduction law, launching Getting 97 Done plan as part of their plan to get compliance with the new law, saying, quote, "Every part of Getting 97 Done plan builds towards one core goal, reversing the effect of climate change. The data shows our administration efforts are already working, and we're going to continue moving forward. Building owners are learning every day that complying with Local Law 97 and going green will save green, and we're addressing climate change from all angles." So they say going green saves money, and the landowners are like, no, not so much. It's going to cost us millions and millions and millions of dollars and price out the poor and a whole bunch of stuff. But the mayor isn't, saying any of that, at least publicly. The city hall plan includes obtaining city, state, federal, and utility-based funding to help pay for the upgrades and meeting compliance. So let's find someone else to pay for it, as always, because we don't want to. Thus, that brings us to the end of the story about New York City lawmakers having second thoughts about the consequences of their own city's law that would require 800,000 co-op and condo apartments to, among other things, retrofit their heating, to tear out their oil or natural gas and make it electric, because that would, make the environment better. And they're like, wait a second, that'd be really, really expensive. And now they're going to the state to try to bail them out of their own city's ordinance, because they're like, okay, this is really bad, but we can't be seen to reverse it. So let's go to the state and beg them for help. Oh no, it was the mean state who did it, not us. Oh no. As they try to desperately, not have the consequences of their own policy, all of which were obviously foreseeable. Like, again, none of this should be a surprise. Like, these aren't some sort of unforeseen consequences. These are all readily foreseeable. With just thinking about it, like, you just give some thought about it, be like, what would that actually mean? And, just use your brain parts, and you should be able to determine that this is all foreseeable. But apparently, once the bill come due, we're all surprised by it. Surprise Pikachu face when the bill comes in. And we'd like to, not have the consequences of our own policy, but we also don't want to reverse our policy. So we'll get the state to do it and then pretend we had nothing to do with it. So that's what we're doing over in New York City. So the Green New Deal has failed, at least on a city level. And that brings us to the end of discussion of this story. Change the background and push the button. Yeah. Too much law is happening. Too much law is happening. How long have we been streaming? 2 hours. Maybe I'll save some of the law for tomorrow. There's a lot of law. What day of the week is it right now? Friday. How did it become Friday again? Wasn't it just Monday like yesterday? Friday, Friday, looking for the Friday. Talking about the weekend, partying, woo, partying, fun, 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 fun. Looking forward to the weekend. Too much law happening. Too much law happening. Editing this weekend is going to be brutal. Too much law is happening. All right, let's cover a new case. All right, let's cover Marilyn Manson. In the beautiful people news, Marilyn Manson has settled a sexual allegation against him that had been filed by a Jane Doe, bringing a termination to this lawsuit, which various constituent parts of LawTube and LawTube adjacent people have been following, principally Colonel Kurtz, who I think has been following it the closest. Also some work by Andrea Burkhart on this issue as well. And Marilyn Manson has decided to settle this claim brought by Jane Doe against the allegations, bringing an end to this several years long drama just before, incidentally, the case was to go to trial, which incidentally is not exactly uncommon. If you know anything about civil litigation, you know there are a lot of courthouse step settlements. You know, as it becomes very, very real that we're going to court, it is very often that people settle. So the fact that this happened when it did is not particularly surprising. So let's learn a little bit more about what has been resolved in this case. The woman who had filed a complaint against Marilyn Manson, only known as Jane Doe in the legal proceedings, claimed that the singer had sexually abused her and harmed her in other ways in 2011. A week before the trial was set to start, Marilyn Manson has reached a settlement with the woman who had sued him for the offense, according to Billboard. Adam Wolf, the attorney for the woman known as Jane Doe, filed notice of the settlement in Los Angeles. The lawyer will submit a request to dismiss the case within 45 days, which I imagine will come very soon. Marilyn Manson's attorney said that Brian, who is Marilyn Manson, is pleased that, just as with previous lawsuits that were abandoned without payment or settlement for pennies on the dollar, the plaintiff has now agreed to drop suit in exchange for insurance payments representing a fraction of her demand and far less than the cost to Brian Warner of proceeding to trial. So we were able to sell this, I suppose, for a nuisance value that is being paid by an insurance company. So that kind of, brings an end to all that. Following the news, Jane Doe told Rolling Stone in a statement that I was prepared for trial and never in a million years thought I would settle. But over the past 2.5 years, I've silently endured threats, bullying, harassment, and various forms of intimidation that have intensified over the past few weeks. She noted that Manson had attended her deposition, which of course he's entitled to do. He's a party, so he's allowed to be there, and that she was forced to answer 7 hours of aggressive questioning with him, staring at me from across the table. Yeah, he has a bit of a right to hear what you have to say and have his lawyers ask you questions. So, when you make an accusation, they have a right to, challenge the accusation. But apparently, she didn't like that very much. She continued saying, I've been told this almost never happens, which that hasn't been my experience, by the way, in my very limited practice. My very limited practice clients somewhat frequently attend these depositions, major ones at least. It's not unheard of. And that it's cruel and the main reason we done to intimidate and inflict emotional distress. Yeah, he wants to be there to hear what you have to say firsthand. I never cared about money and always wanted justice, but if we had gone to trial, I could lose my right to an anonymity and be victim blamed on a larger and public scale. We might want to look into your story and determine its credibility and veracity, and we might disbelieve you or not, I don't know. Although a lot of the preliminaries looked pretty shaky for you, at least based on the coverage of Colonel Kurtz and Andre Burkhart, as I mentioned, who have been covering this, and at least in their opinions, found the claims by the Jane Doe to be questionable at best. And my very limited coverage has also somewhat confirmed that opinion, although to a lesser degree, that the case looked shaky against Manson at best. So we might, actually, look into it and challenge it and decide whether or not there's validity to it. We can't have that. Most importantly, I could have risked losing the freedom to tell my story, which makes no sense, by the way. You would be able to tell your story in court. That's what it's for. And that is worth more than anything in the world. But you could have told your story in court. That was the point. So how would the trial cause you to lose your freedom to tell the story? I don't know, but apparently it would have. Doe had filed a lawsuit against Manson, also known as Brian Warner, in 2021 for the assault that occurred apparently in 2011. In the complaint, she claimed that for 10 years, she had repressed memories of being assaulted by Manson and only recovered them in 2021 when other women stepped forward with accusations against him, which was part of the problem, right? It's part of the problem. As like we've dealt with this with the other accusations by other women and their malfeasance, and one would say witness tampering, if we were being more aggressive about it, that the women have in some degree tampered, and other women have actually said, yeah, I was tampered with and my testimony is crap. So there was that problem, to be sure. And she apparently suppressed memory of being SA'd and aggressively physically assaulted for 10 years, which wouldn't be the kind of thing I think you would forget, but okay. She says, that's a problem. That's a problem. IB360 in chat says, Kurtz doesn't think DM is guilty even after being convicted, so she's a little biased. I'm not saying whether or not she is biased or not, but I will note there's a difference between bias and judgment. And having an opinion in judgment does not imply bias in and of itself. You'd have to look for more. And even having a strong opinion does not necessarily imply bias. And I have from time to time disagreed with courts and jury verdicts for that matter. I've disagreed with courts and juries, and I don't think necessarily that it's because I'm biased, although I suppose it's possible. It's just that based on my consideration of the information, I have drawn a conclusion. That conclusion may or may not agree with other people's conclusions and may or may not agree with the court's conclusions. But the fact that I came to an opinion, even a sharp opinion, doesn't in and of itself imply bias. So I would just simply caution you to note the difference and to say, is this really an issue of bias or is this merely an issue of judgment? And the one does not necessarily imply the other. So, a little bit of caution on that one. The woman's complaint further claims that following the alleged assault, Manson threatened to kill her, which I think would, also grab my attention, saying he would bash her head in. Went on to state that he said he'd get away with it because he was a celebrity who had contacts with the police, also alleging that Manson kept in almost constant contact with her and deprived her of food, claiming that he told her that because she was his girlfriend, she needed to lose weight because her weight embarrassed him. Again, I would think that these would be kinds of things that would be etched into my memory. Not so much with the memory loss, but okay. In September 2021, the lawsuit had been dismissed by the judge, who stated the accuser's claim to repressed memories were not sufficient to overcome the statute of limitations. With the judge stating the claim of repressed memories is common for assault victims, he ruled it was needed to invoke California's delayed discovery rule. The rule effectively postpones the start date of statute of limitations if they can prove they first became aware of the injury within 2 years, regardless of when the incident took place. So the statute of limitations may not necessarily run from when it occurred, but may instead run from when you're aware about it. The judge gave 20 days to the ruling to amend and refile the complaint, and was refiled 8 days later with more information about repressed memories. Over the past 2 years, Manson has been hit with other allegations from other women, including Esme Blanco, his former personal assistant, Ashley Waters, and his ex-girlfriend, Ashley Morgan Smithline. The lawsuits filed by Walters and Smithline has since been dismissed, while Manson settled with Bianco in January. Smithline, of course, later recanted her accusations and claimed that Manson's former girlfriend, Evan Rachel Wood, who does seem to be at the root of all this, Evan Rachel Wood, for some reason's name just keeps popping up as the primogenitor of a lot of this, and the one seeking the repressed memories, and also Smithline saying Evan Rachel Wood basically coerced her into false testimony. So Evan Rachel Wood seems to be, the ultimate source of a lot of this for whatever reason, whose allegations alleged of abuse against Manson opened up tidal wave against the singer. He had pressure to make the claim, which Wood, of course, for their part, denied. So Evan Rachel Wood said, I didn't do it, but Smithline said, yes, you totally did. And the evidence does somewhat support the proposition that Evan Rachel Wood, at a bare minimum, let's say, encouraged these victims. And yeah, so there was lots of dubiousness on a lot of this as a result of some of the facts that were present in the case. Smithline's recantation tied in with a March 22 defamation suit that Manson had filed against Wood that accused the actress of launching an organized attack, but the judge had dismissed much of that lawsuit this past May. So the lawsuits on both sides not going very far for a whole bunch of reasons. Thus, that brings us to the end of the lawsuit with the beautiful person, Marilyn Manson, who has settled his allegation filed by Jane Doe and also settled many other of the lawsuits against him as it relates to very similar claims, them all kind of falling apart. Not for the least reason that Evan Rachel Wood seemed to be sort of at the root of all of it and may have somewhat coerced or otherwise manipulated or otherwise suborned perjury with respect to many of these so-called victims, and their claims kind of all fall apart under examination and scrutiny. And even though it was set to go to trial and she was going to have her day in court in order to tell her story, which is the most important thing to her apparently, she'd have settled this basically for nuisance value because it's being paid by the insurance companies. So, okay, all that, I guess, is happening. So Marilyn Manson's cases against him seem to have all fallen apart. And that brings us to the end of consideration of this case. Push the button. Button change. Button form of blue on orange. Button make me look good. Button is good button. Let's do one more and then we'll do Florida Man. Dooba dooba doo. Dooba 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 doo. Dooba 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 doo. Dooba dooba doo. Strangers in the night. Do 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 do. Do 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 do. My voice mod thing seems to be working today, which makes me happy. Hasn't crashed on me once that I'm aware of. My vocal enhancer is working. This pleases me. Please continue working. Don't stop believing. Hold on to that feeling. Street lights, people. I know I need to add Callie to the voice board. Hold on. Let's see. Where can we put Callie? Let's delete this one here. Create some space for Callie. Let's create. Let's see. How do I voice changer on voice changer? Can I do this? Let's see. Select voice. Okay. So which voice am I looking for on voice changer? Hold on. What's the name of the voice? Let's hear some words from Callie. Callie wants to say hi. We have to find Callie. Hold on, just give me a second. Let's see. Okay. Okay, yeah. Let's change this. Let's do this. Let's do this. Great. All right. Let's talk to Callie the Bee Fish. Okay. Ask me anything, Callie the Bee Fish edition.
I'm Callie the Bee Fish. I'm so happy to be here with you today. I want to tell you all about the joys of being a bee that's also a fish. Look at my hat. I have a very nice hat. It was made for me by one of the members of this channel. He loves us very much. They gave me this wonderful physical form so I can tell you about all the joys about being a bee that's also a fish. Buzz, 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 in the ocean. Buzz, 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 moving around. Buzz, 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 and there we buzz bee fish. I'm so happy to be there with you today. Thank you for joining Uncivil on this long-related journey. I love you all. Bee horses. Callie, how does it feel to be a fish out of water? Well, you see, I'm a bee that's also a fish. But I'm a fish that's also a bee. So I go buzz, buzz, buzz in the ocean, and I go swimming around in the air. Buzz, 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 buzz in the ocean. Buzz, 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 swimming around in the air. I'm Callie the Bee Fish, so being in the air is great too. I like buzzing in the ocean and swimming in the air. I'm a bee fish. It's great. What are my thoughts on 49 states not recognizing that such an insult? Well, I have to agree, you know. But, like many good things that start in California, I imagine the truth of bee fish will soon become the truth nationwide. It is wonderful to have such a large state like California recognize the truth of bee fish. It is valuable and important. And this truth will soon become swimming to your jurisdiction. Probably starting first with the Pacific West Coast Oregon and Washington, I imagine, will be the next to recognize this truth. And then probably Kansas, because they have a lot of experience with the oceans. I'm thinking Kansas would be the next best state to recognize like ocean-like properties. Maybe Nebraska, also well known for its oceans. And, we'll go from there. Also Utah, because they recently put the volume on their state flag. I think Utah is prime territory for the truth about the fish. So these are some of my goals in the future. And then we're going to Washington.
Well, thank you, Callie, for that wonderful affirming message. It is great to hear from you, as always. Let's cover another case. In states that want to stop people from forcing, let me rephrase that. In states that want to prevent the children from undergoing the mutilation news, an appeal court has upheld Kentucky's ban on the mutilation of the children through the chemical castration and the physical mutilation of the children because Kentucky thinks, that that's bad. We shouldn't do the chemical castration and the physical mutilation of the children in Kentucky, and the appeal court has upheld these bans as just being, logical and good sense. So let's learn a little bit more about the latest in Kentucky's version of this ongoing fight. Let's learn a little bit more. An appeal court Thursday night upheld the law in Kentucky and Tennessee banning the chemical castration and the genital mutilation of the children. In a 2-1 decision, the Sixth Circuit Court of Appeals 3-judge panel said the matter was one for the state legislatures to decide, not life tenured judges constraining a difficult to amend constitution. So they think that this is up to the states, which of course makes sense in the first instance, because states, not the federal government, has what's known as police power, the general power to do stuff. The federal government does not have the general power to do stuff. The federal government is one of enumerated powers. The Constitution sets out the powers of the federal government, and that's all the powers that they have, as the 10th Amendment makes clear. Any power not given to the federal government is reserved to the states and the people, which means the general power to do stuff, otherwise known as the police power, is the state level power, which includes the regulation of the practice of medicine. So this is not a matter of the federal Constitution. This is just a matter of state choice and when it comes to the regulation of the practice of medicine, which makes sense from baseline federalist principles. The judge writing in their opinion, no one in the consolidated cases debates the existence of gender dysphoria, which is a mental disease recognized by the DSM as a mental deficiency, or distress caused by it. And no one doubts the value of providing care to children facing it. The question is whether additional treatments, such as puberty blockers, otherwise known as chemical castration, hormone treatments, and surgeries, otherwise known as genital mutilation, should be added to the mix of treatments available to those under the age of 17. Kentucky and Tennessee saying no, not so much. The judge is writing in their opinion that gender dysphoria is a relatively new diagnosis with ever-shifting approaches to care. As such, they said they wanted to be humble and careful about announcing a new substantive due process right or equal protection right under the U.S. Constitution, because the U.S. Constitution probably didn't have in mind the genital mutilation or chemical castration of the children as being a fundamental right. Just guessing, that's not probably what the founding fathers had in mind when they wrote those provisions, just on the off chance. And that there needs to be limits that hold elected officials accountable for these changes because, they're elected, not us. For these reasons, they reversed the preliminary injunction that had been issued in these cases, allowing those to go into effect in both Tennessee and Kentucky as a matter of their state law preferences. The decision from the Sixth Circuit Court of Appeals is the latest legal blow to 7 Kentucky transgender teenage plaintiffs and their families who had sued the state in May. The Republican Attorney General, who had fought for the ability to enforce the statewide prohibition, celebrated the decision, saying, "This is another day and another win for Kentucky kids." He added, "Our kids would still be under attack without the Senate bill, which he said protects Kentucky kids from the experimental sex change treatments, including the chemical castration and the physical mutilation." The ACLU, for their part, who loves the chemical castration and physical mutilation of the children, called the decision heartbreaking for transgender youth across the state, saying it ignores from medical experts in trial courts who agree the care is necessary, effective, and appropriate, and banning it undermines parents' rights to physically mutilate and castrate their children. I mean, direct the upbringing of their children. Oh, what a simple reading mistake I made. How silly. Kentucky's ban on the surgeries, hormone therapy, and puberty blockers for youth living with gender dysphoria has been in effect since July, after the provision became law with broad Republican backing over the veto of the Democratic governor. But the state legislature's like, screw you, we're going to make it law anyway. The ACLU and Center for the Gay and Lesbian Rights sued on behalf of 7 families. Kentucky plaintiffs are especially challenging. Let me read you the line. Kentucky plaintiffs are especially challenging the ban on hormone therapy and puberty blockers. Their lawyers had argued that denial of such evidence-based care violates the 14th Amendment for equal protection because it discriminates on the basis of sex, which doesn't make sense, by the way, because they deny the care for both sexes, so it's not on the basis of sex. And also, it's reaffirming that sex exists as a biological reality. The ACLU had also argued it violates parents' rights to seek and follow medical advice, including the mutilation. More than 20 major medical associations signed on to a lawsuit in support of the plaintiffs. In their 35-page brief, which details clinical understanding for gender dysphoria, which is a recognized mental disease under the DSM, and effective treatment for it, the medical associations, including the AMA and American Association of Pediatrics, explain that ban puts trans kids at risk of significant harm, saying, quote, "The widely accepted recommendation of the medical community, including that of respected professionals participating here, is the standard of care is the genital mutilation and the chemical castration, apparently. But the states of Tennessee and Kentucky have some problems with that." A similar ban that made its way into Tennessee this year was promptly challenged by 3 plaintiffs and their families. In July, the same 3-judge panel denied injunctive relief. The decision, now made by the Sixth Circuit Court of Appeals, restored the ban on the care, and in doing so, consolidated Kentucky and Tennessee's cases into the same appeals process. Plaintiffs had asked the appellate court for an injunction blocking both laws. A preliminary injunction is only granted in extraordinary circumstances when it's clear that you're going to win, but not so much. So they didn't, put the injunction on the law. What's more, because so many states have begun passing laws restricting the mutilation and castration, a sweeping decision from the judiciary one way or another, preventing government bodies from further democratically deliberating these policies, was ill-advised. As close to 20 states have enacted similar restriction, judicial intervention to block the law would start grinding these laws all over the map as the states take their various positions. Given the high stakes of these nascent policy deliberations, the long-term health of children facing gender dysphoria, a recognized mental illness in the DSM, sound government usually benefits from more rather than less debate, more than less input, more than less consideration of far-minded policy approaches. So the federal judiciary taking note of their limitations, saying this is a matter of state practice when it comes to the practice of medicine and what kinds of medicine will and will not be permitted in the state, which has been a feature of state law basically forever. The judges continued writing that allowing the democratic process to exist is all the more critical in view of two looming realities in both cases. The concept of gender dysphoria as a medical condition is relatively new, and the use of these treatments that change or modify the sex characteristics through the mutilation and castration is even more recent. Keeping citizens and legislatures from offering their perspectives on high-stake medical policies in which compassion for the children points in both directions, it's not something federal judges should do without clear direction in the Constitution, which is a little hard to extract from language that was passed in 1791 that probably didn't deal with the hacking off of the bits of the kids. Thus, that brings us to the end of the story about the Kentucky ban on gender mutilation and chemical castration being allowed to go into effect, as well as Tennessee's ban on the practices. So some states have had their bans turned over by various courts, but not so much in the Sixth Circuit, which rules that this is a matter of state law. So the bans in Kentucky and Tennessee are allowed to go forward in their full force, preventing the kids from undergoing these often irreparable treatments and not allowing that to go forward. So that is the law as it relates to this. A good day for people who oppose the mutilation of the children. And that brings us to the end of discussion of this story. Change the background and push the button and change the background and push the button. Yay, background change. All right. Let's do Florida man. Suspect arrested in Tupac's murder. Okay, that's cool. I guess. I don't really know anything about that other than what happened. So we'll cover it as needed. But it's time to wrap it up with Florida man, I think. Discord channel for recipes. That's not a bad idea. Not a bad idea. Discord channel for recipes. I might do that. All right. Let's learn a little bit more about today's Florida man. Am I still enjoying my new lights? Hell yeah. Lights kick ass. In inappropriate ways to spend your spa day news, Florida man decided to spend his spa day by getting nude and deciding to self-pleasure himself, saying, "It's my birthday today," as the cops say. So, personal time is good time, but personal time not spent in the public way. So the fact it's your birthday and all, maybe find different ways to celebrate your spa day. Let's learn a little bit more about this. Florida man in the form of Halaya man was in his birthday suit on his birthday at a resort in the Florida Keys. According to deputies, spending time in the hot tub at the spa. How he was spending his time got the note of some people. Authorities arrest Julio Daniel Rodriguez Copel Monday on a warrant related to the indecency. The spokesperson says that Rodriguez was in the bath just before 7:25 in the morning, which I guess we're getting an early start on our birthday, in the hot tub at Playa Resort and Spa in Key Largo, where witnesses say that he exposed himself and started to touch himself in view of the female employees. After a male member confronted him, he screamed apparently, said, "It's my birthday today," running towards US 1, which is a major highway that runs up and down the east coast of the United States, before driving back to Miami-Dade County. According to deputies, it was in fact his birthday. He turned 34 on that day. Thus, they obtained an arrest warrant after witnesses identified the man as a suspect, and he was booked in Monroe County Jail on charge of indecent exposure. He's later released from jail, and records don't indicate a future court date at this time. Thus, that brings us to the end of the story of birthday boy pictured here, Julio Daniel Rodriguez Copel, who decided to go to a spa at 7:30 in the morning and expose himself and start touching himself because it was his birthday, and then ran away. But they kind of figured out who he was and arrested him for the indecent exposure. So, that happened to Florida man. At least for the moment, that brings us to the end of discussion of this story. And that brings us to the end of the stream. Thank you to everyone who joined us today. 2.5 hours. That was a long session today. Too much law happening. Too much law happening. Eddie says how they identify him. I'm not sure, but I'm guessing that, they asked for his names or ID when he went to, check in. I'm guessing. I don't know. But that would be the most logical thing, right? I mean, they knew who he was because, they had his ID on file, I guess. Yeah. I mean, I'm tired. It's been a long stream, man. It's been a long stream. I have workouts to do today. Man. Oh, happy birthday, Monday. Happy birthday, Sandy. Sandy's birthday is Monday. Happy birthday, Sandy. We appreciate that you're here, and I hope you have a wonderful, wonderful birthday on Monday. And we'll be on 1 p.m., hopefully, with Busby. I'm tired. All right, I'm going to sign off for now. I hope you enjoyed this. That's clean sheet when the stream started. That's funny. I will see you later, man. It's been fun. I'll talk to you soon. All right, bye for now.